I welcome the participants in this session on Indian ways of handling tribal affairs. We will be going through some constitutional provisions and also the 5th and the 6th schedule for tribal development. The constitution makes special provisions for the scheduled caste and scheduled tribes, the backward classes and the minorities and Anglo-Indians. Under Article 342 of the Constitution, the President has the power to specify the tribes or the tribal communities or parts or groups within them as scheduled tribes in relation to the state or the union territory. In case of the state, the President must consult the governor of the state. In order to safeguard the interest of the scheduled tribes, under 89th Constitutional Amendment Act of 2003, a separate National Commission for Scheduled Tribe was set up. It consists of a chairperson, a vice chairperson and 3 other members. They are all appointed by the President of India by warrant, underhand and seal. In 1999, a new ministry for the tribal affairs was created to provide a sharp focus for the welfare and development of the scheduled tribes. The ministry should coordinate all activities relating to the scheduled tribes. There are certain constitutional provisions and legislative measures. The constitutional provisions for the scheduled tribes can be categorized into 4 categories. Constitutional Amendment Acts for the empowerment of the scheduled tribe. 41st Constitutional Amendment Act 1984. That is the 51st Constitutional Amendment Act, which provided for the reservation of seats in the Lok Sabha for the scheduled tribes in Meghalaya, Arunachal Pradesh, Nagaland and Mizoram, as well as in the legislative assemblies of Meghalaya and Nagaland. 57th Constitutional Amendment Act of 1987 provided the reserved seats for the scheduled tribes in the legislative assemblies of the states of Arunachal Pradesh, Meghalaya, Mizoram and Nagaland. And further, 65th Amendment Act of 1990, and this act provides for the establishment of a multi-member National Commission for Scheduled Tribes and Scheduled Caste in place of special officers for the Scheduled Caste and Scheduled Tribes. 72nd Amendment Act of 1992. This act provides for reservation of seats for the STs in the legislative assemblies of Tripura. 77th Amendment Act 1995. The act provided for reservation in promotion in government jobs for SC/STs. Then 82nd Amendment Act 2000, and this act provided for making of any provisions in favor of SC or ST for relaxation in qualification marks and in any examination or lowering the standards of evaluation for reservation in matters of promotions to the public services of the center and the states. Then it's the 83rd Amendment Act 2000. In this, the act provides that no reservations in panchayats need to be made for the scheduled caste in Arunachal Pradesh. The total population of the state is tribal and there are no scheduled castes. Then it's 93rd Amendment Act 2005. This act empowers the state to make special provisions for the socially and educationally backward classes or the SCs or STs in educational institutions, including private educational institutions which are whether aided or unaided by the state, and except the minority educational institution in Article 25. The Supreme Court declared that reservation in private unaided educational institutions was unconstitutional. There are some legislative measures also for empowerment of the scheduled tribes. First is the forest rights. The recognition of Forest Rights Acts 2006 to recognize and vest the forest rights and occupation in forest lands to forest dwelling scheduled tribes. Then it's the fair compensation, that is right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013, that is a safeguard against displacement of the scheduled tribes. A very important act is PESA Act, that is Provisions of Panchayat Extension in Scheduled Areas. The Panchayat Extension to Scheduled Areas Act, that was in 1996, provides that the Gram Sabha or the Panchayat at the appropriate level shall be consulted before making the acquisition of land in the scheduled areas. Then legal services. The Legal Services Authorities Act 1987 provides for legal services to the members of the scheduled tribes. The Prevention of Atrocities Act. The SC and ST Prevention of Atrocities Act 1989 has been introduced to prevent the commission of offences of atrocities. It aims to provide for the tribals for such offences and for the relief of rehabilitation of the victim of such offences and for matters connected therewith or incidental thereto. Now, there are two schedules which are very relevant to this tribal development, that is the 5th schedule and the 6th schedule. The 6th schedule concerns the northeast states. Now, the 5th schedule under Article 244(1) of the Constitution of India essentially provides for a holistic guarantee for tribal people in the country and is the backbone in the legal framework in the tribal areas. The makers recognize the need for protection and special administration of areas predominantly inhabited by the tribals or the Adivasi people due to their cultural uniqueness, vulnerability to external exploitation and development gaps between these communities in comparison to the mainstream regions. So, the schedule deals with the administration and control of specified areas which are termed as scheduled areas and the tribes living in these areas. The most important right provided under this schedule is the prevention of land alienation through the land transfer regulation, where no land or immovable property in these areas can be transferred by way of sale or lease to person other than the tribals. Now, for the Adivasi women also, the 5th schedule of the Constitution provides protection of their lands and natural resources from being alienated to the outsiders. If we go in the features of the 5th schedule of the Constitution of India, administratively and legally, the habitats of the land is divided into 3 groups. The first group comprises the areas declared as the scheduled areas under clause 6(1) of the schedule 5 of the Constitution. Under section 6(2) of the schedule 5, the President of India may at any time order either deleting an area from the scheduled area in Constitution with the governor of the state. Now, thus the specification of scheduled area in relation to a particular state or union territory is notified by an order of the President after consultation with the state governments concerned. Now, it is important to mention here the Debar Commission, which commented that the law and order approach followed by the British to exclude the tribal areas from normal administration continued even after independence. However, the government evolved a criteria to be followed following the declaring an area as scheduled areas, which includes preponderance of the tribal population, compactness and reasonable size of the area, underdeveloped nature of the area and marked disparity in economic standards of the people. These criterion have become well established over the course of time. Now, if we look into the provisions, important provisions of the 5th schedule, the governor of a state has been entrusted with special responsibilities in the administration of the scheduled areas in the state. The governor has been vested with legislative powers and he or she is required to prepare a special report annually or whenever required and submit it to the President regarding the administration of the scheduled areas, that is section 3 of the schedule 5. The union government can issue appropriate directives to the state government as to the administration of the scheduled areas. The 6th schedule of the Constitution makes separate arrangements for the tribal areas of Assam, Meghalaya, Mizoram and Tripura. Article 244A was added to the Constitution through the 22nd Constitutional Amendment Act 1969. It empowers the Parliament to establish an autonomous state comprising certain tribal areas of Assam and for local legislature or Council of Ministers or both can create. This schedule provides for two kinds of governing units in the tribal areas: the autonomous districts, councils and the autonomous regions. The governor has the power to include, exclude or diminish any of these areas or define their boundaries. There shall be a district council for each autonomous district comprising not more than 30 members and a regional council for autonomous regions. The power of administration shall be vested in these districts and autonomous councils, and the governor shall be entitled to make rules for the constitution of the council and its composition, and terms of the office appointed of the officers and staff, and procedures and conduct of the business, and all these are taken control by the governor. So this 5th and 6th schedule areas will be discussed much in details, but the scenario of change and development of the tribal area is really a matter of great concern today, and it needs a greater attention from even before the tribal leaders who are at the helm of the affairs and the machinery of development administration which are working at present. So I thank you all the participants for this patient hearing, and I am sure that when we discuss this at length, you will be really enjoying these sessions. Thank you.